Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 56, which is titled as CPIO, Supreme Court of India versus Subhash Chandra Agarwal. So CPIO here is Central Public Information Officer, whose office is constituted under the RTI Act. Now, this case is majorly premised on the Right to Information Act. And what is happening in this case, there is Mr. S.C. Agarwal, who is an RTI activist, and he is filing RTIs seeking the disclosure of information with respect to declaration of assets by the judges of Supreme Court and High Courts to Chief Justice of India. Also, he is asking for disclosure of correspondence between the collegium and the government regarding the appointment and transfer of judges. And also, he is seeking the details of candidates who are either recommended or not recommended by the Supreme Court collegium. Now, basically, this particular demand is arising out of appointment of few judges who were falling in who were less senior than the other judges who were not appointed as judges by the Supreme Court collegium. Now, herein what happens, this Mr. S.C. Agarwal, he files the RTI, and however, these RTI applications are denied by the CPIO of the Supreme Court. The CPIO of the Supreme Court cites the reason mentioned in Section 8. 1J, which is that information which relates to the personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual unless the CPIO or the state public information officer or the appellate body, as the case may be, is satisfied that the larger public interest justifies the disclosure of such information. So the CPIO of Supreme Court cites Section 8(1)J as the reason and denies the disclosure of the information sought. Now, Section 8 of the RTI Act, it basically deals with exemption. That in what cases RTI Act, you can, even if you file the RTI Act, the authorities do have a power to deny granting of the information to you. So the CPIO is basically invoking Section 8(1)J, the personal invasion and right to privacy clause, that in invasion of which will also be unwarranted. And he is also saying that it is the information that is held in a fiduciary capacity under Section 8 itself, and therefore such an information cannot be disclosed. Now, what happens is that there is an appeal. There is a CIC, Central Information Commission, coming into force. So Central Information Commission is a body constituted under the Right to Information Act, and it ensures the execution or the implementation of the RTI Act. Now, CIC herein is basically ordering Supreme Court of India to disclose the information regarding the collegium decision making as well as the declaration of assets. Now, what happens when CIC issues the order? The CPIO of Supreme Court. So CPIO of the Supreme Court, he goes and challenges such decision before the Delhi High Court. Now, in Delhi High Court, there is a single bench who is deciding the case, and the judge sitting there, he orders that such disclosure to be made. He upholds the order of CIC. Now, Delhi High Court also directs the disclosure of the information sought, and now Supreme Court is taking the appeal before it, because a three judges bench is referring the matter to the Supreme Court of India from the Delhi High Court. Now, herein the issues that are framed. So the issues that are framed in this case are, number one, and just take you through the issues. Yes, so in this case, the first issue that has been framed is that whether, number one, is Chief Justice of India is a public authority under the RTI Act, and whether the information such as judges' assets, declaration of judges' assets, and the deliberations that are happening in the collegium, are these allowed to be disclosed under RTI Act, or are they falling as an exemption under the RTI Act? And how will such information, if such information is disclosed, how is it going to affect the judicial integrity, judicial transparency, judicial independence, and doctrine of separation of power. Now, herein, the court basically is deciding, it is balancing the transparency and judicial independence. The court herein is saying that, firstly, court halted the CIC's orders. Court put a stay on CIC's order, and then what the court is actually, laying down in this case, it is saying that judicial independence does not stand in contradiction with the need for transparency. So it is not that where judicial independence exists, transparency cannot come. So judicial independence and transparency can exist together. And CJI's office, or judges of office of a judge, is not distinct from that of the Supreme Court, because it is ultimately the judges who are constituting the Supreme Court itself. Therefore, when Supreme Court of India is the public authority, then CJI's office is also a public authority, and it comes under the ambit of RTI Act. So transparency is not contradictory to judicial independence. Rather, transparency strengthens judicial independence. That is what the judges are determining in this judgment. It has been emphasized that constitutional functionaries are not above accountability. So they are also accountable. Just because they are sitting in a privileged position as constitutional functionaries does not mean that they are not accountable. They need to be transparent as well. And information such as asset declaration by judges is not exempt per se, but it can be subject to reasonable restrictions to provide privacy and dignity of the person concerned. Court also clarified that even if CGI is sitting in a fiduciary capacity, as is asserted that Section 8(1)(e) protects the fiduciary capacity, and it does not put an absolute bar on disclosure. So we need to bring a test. We need to balance that public interest in privacy with public interest is to be balanced with the privacy. And court herein is basically laying down that information of the judges, for example, the personal information, where their children are studying, or what are their medical records, what hospital they go for the treatment, what do they do for for their medical health care, choice of medicines, income tax returns, etc. These are personal information. Also, even if there are disciplinary proceedings, etc., these are going along. These are disciplinary proceedings or internal, reports, evaluation reports, ACRs, qualification, performance. These choices are basically personal information, but we need to draw a line that which information needs to be protected from invasion and which information is needed to be disclosed for a larger public interest to be satisfied. Now, there can be multiple information which are personal in nature. For example, even the assets you are holding are personal in nature, but what medicine I am taking, that is also personal in nature. Now, if I want to disclose an information for a larger public interest, it cannot be the choice of medicine or the choice of hospital I am choosing for my medical treatment, but to maintain transparency, to maintain accountability, there can be a disclosure of assets. Now, coming on to another issue, how collegium deliberations of collegium are to be disclosed through RTI. Court herein is observing that collegium deliberations are sensitive, because everyone knows who is participating in the collegium. Now, the sanctity is also put at hold when collegium deliberations are out there, because it is a confidential process. The deliberations are confidential. These are sensitive matters to be decided, and so sanctity and confidentiality of the collegium needs to be protected, because it is again a sensitive discussion, and therefore that confidentiality, that also should be protected. However, once the decision has been taken, we can make a post facto declaration, but throughout the decision, when the decision is in making, that we need to balance transparency along with the need of sensitivity and confidentiality, so as to ensure that judicial independence and institutional integrity is also protected. Now, the court herein is emphasizing that a third party may seek the information that he is asking under Section 11 of the RTI Act, and when we are looking at what information is to be disclosed and what is not to be disclosed, there are tests that we can use. One being the proportionality test, and other being the public interest overriding test, right? So each request, whatever the request is for information, it should be assessed on the case to case basis. Now 81J, if we read 81J of the RTI Act, it is striking a balance between privacy and public interest. Okay, so now if someone files an RTI against a Supreme Court judge seeking that which hospital does this judge go to or which school does his child go to, that might be an invasion of privacy, because larger public interest does not need that what hospital that person is, judge is using, or where are his kids studying. That is not concerned with public interest. But declaration of assets might in some cases be related to public interest. And most recently we have seen in 2025 itself that there has been a declaration by the Supreme Court judges. So in the newspapers, a full page information was given, even on the platforms like Bar and Bench, like Live Law. We are seeing that the asset declaration by the Supreme Court judges has been made. And of course, because of the controversy that have been arising due to some corruption cases by a high court judge. Now herein, these kind of information, if when sought, it becomes relevant to disclose, and therefore each request for information must be assessed on a case to case basis. Now herein, Justice Chandrachud also, who is always vocal about open governance, open transparency, he's also asserting, he's also saying, as we have discussed, that judicial independence is not contradictory to transparency, and judicial independence cannot be used as a shield against transparency, because both go hand in hand. However, there has been a cautioning opinion also coming in this judgment, which is saying that if you allow indiscriminate disclosure, then that also will bring unwarranted RTI access, which could impair judicial functioning and the sanctity and confidentiality of collegium deliberations. Now, in this judgment, Supreme Court first time, it's a very progressive judgment in my opinion. Also, the asset declaration by the Supreme Court judges, this case becomes a little more relevant. Okay, so now here in the first time, Supreme Court is declaring itself to be accountable under the RTI regime, because it is drawing the parallel that if judiciary, if High Court, if Supreme Court is a body which is a public authority, then why not judges? So it is setting a precedent for increased transparency, and in pursuance of such precedent, there is a disclosure by the Supreme Court judges of their assets, which is a remarkable, commendable step that ensures public confidence in the judiciary also. It is also reinforcing constitutional morality, because constitutional morality basically lies in good governance. It basically it is a constitutional morality is basically a tool that is used for accountability, for ensuring citizen participation, and on the top, it maintains the constitutional democracy. Now, RTI Act, the framework of RTI Act has been elaborated in this judgment, and this judgment is also providing a very nuanced and a very structured architecture to the RTI Act. And it is basically laying down that the information that is required to be furnished, that is required to be declared, has to be decided on the case to case basis if it concerns privacy and public interest both at the same time. So there needs to be a harmonious construction of privacy as well as the public interest. And it is navigating the tension. Basically, the judgment, if you see, it is bridging the tension between the right to know and the need to preserve the sanctity of judicial functioning also. Now, it is one landmark judgment which affirms transparency in the judiciary. Coming on to the verdict of the judgment, the court in this case, is upholding the Delhi High Court judgment and directing the CPIO to disclose the asset declaration of the judges. But when it comes to collegium decision making, it is directing the CPIO, Central Public Information Officer of the Supreme Court, to re-examining the request in light of Section 11 of the RTI Act. So this is it, which was held in the case of CPIO versus Subhash Chandra Agarwal, CPIO Supreme Court versus Subhash Chandra Agarwal. Now, court one thing, that declaration of assets was allowed in the judgment, and re-examination was allowed with respect to the collegium deliberations and any other matters that may pertain to third parties under Section 11 of the RTI Act. So this is it for the video on CPIO versus SC Agarwal. I hope the discussion is useful to you. For more such videos, please stay tuned with us on Legal Darshan. Have a nice day, and we will be shortly covering more videos on the AOR examination as soon as possible.